Dear students, I welcome you all to today's lecture on the law of torts. Today, under the law of torts, we shall discuss certain defences. In this lecture, we shall discuss the defences of voluntary non-fit injuria, the defence of necessity, and also the defence of plaintiff, the wrongdoer. Before proceeding further, we shall discuss the objectives of today's lecture. Number 1, to understand the concept of voluntary non-fit injuria as a defence under the law of torts. Number 2, to understand the essential requirements of the defence of voluntary non-fit injuria. Number 3, to understand the situations in which this defence is not available. Number 4, to understand necessity as a defence under the law of torts. Number 5, to understand the concept of plaintiff as a wrongdoer as a defence under the law of torts. The maxim voluntary non-fit injuria is commonly used to mean that the plaintiff consented to a course of conduct which caused harm to him or her, and by virtue of such consent lost the right to a remedy in the law of torts. Voluntary non-fit injuria is in modern language replaced by voluntary assumption of risk. For the defence to apply, the defendant must prove not only that the plaintiff consented to a risk of actual damage, but also that he agreed to waive his rights in respect of such damage. In the well-known case of Crocker v. Sanders Northwest Resorts Limited, the court described the defence of voluntary assumption of risk as follows. I quote, "The defence of voluntary assumption of risk is based on the moral supposition that no wrong is done to one who consents. By agreeing to assume the risk, the plaintiff absolves the defendant of all responsibility for it. It only applies in situations where the plaintiff has assumed both the physical and the legal risk involved in the activity." Unquote. Now we shall discuss the requirements of voluntary non-fit injuria. Number 1. Consent must be freely given and the risk of harm voluntarily assumed. It is necessary for the application of this maxim that the consent must be freely given. The consent is not free if it has been obtained by undue influence, coercion, fraud, misrepresentation, mistake, or like elements which adversely affects a free consent. Whether consent is free or not is a question of fact to be determined in each case. It is generally accepted that moral, social, and economic pressures restrict the plaintiff's freedom of choice. For example, fear of unemployment or dismissal from employment is a powerful pressure which negates conduct by the employee. Number 2. The person giving the consent must be capable of volition. That is, he or she must be intellectually mature enough to appreciate the implications of his or her acts. Majority or full legal capacity is not necessarily required for consent. The courts will take into account all the circumstances of the case in order to determine whether the necessary capacity existed, including the nature and value of the interest affected, the age, intelligence, knowledge, and experience of the person who is alleged to have consented. The third requirement is that consent cannot be given to an illegal act. No consent can legalize an unlawful act or an act which is prohibited by law, and when the tort is of such a character as to amount to a crime. For example, fighting with naked fists, duel with sharp swords, they are all unlawful, and even though the parties may have consented, yet the law will permit an action at the instance of the plaintiff. The fourth requirement is that the consenting person must have full knowledge of the harm or the risk involved as well as the extent thereof. This is sometimes referred to as informed consent. Our courts have applied this requirement to strictly mean that a plaintiff should have knowledge of the particular risk in order to establish voluntary assumption of that risk and the plaintiff should have actually foreseen that risk. For example, with regard to medical treatment, before a patient can validly consent to a medical procedure, he or she must have been adequately informed of the risks and the benefits and the alternatives to the proposed procedure. Such informed consent is based on the rule that every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. In Smith v. Baker, the plaintiff was employed by railway contractors to drill holes for the purpose of cutting a rock. By the help of a crane, stones were conveyed from one side to the other, and each time when the stones were conveyed, the crane passed from over the plaintiff's head. The plaintiff was fully aware of the danger to which he was exposed by working near the crane without any warning being given, and thus had been employed for months. A stone fell from the crane and injured the plaintiff. He sued his employees in the county court under the Employers' Liability Act of 1880. It was held by the House of Lords that as there was mere knowledge of the risk without assumption of it, the maxim voluntary non fit injuria did not apply and the defendants were liable. Fifthly, the consenting party must realize or fully appreciate the nature and extent of the ensuing harm. A plaintiff who exposes himself or herself to dangerous or negligent conduct does not necessarily assume all the risks attached to it. The question of whether there was assumption of risk depends upon whether the person could have foreseen the harm that eventually occurred and accepted it as falling within the ambit. Courts have applied this requirement strictly to mean that a plaintiff should have knowledge of the particular risk in order to establish voluntary assumption of that risk, and the plaintiff should have actually foreseen that risk. For example, with regard to medical treatment, before a patient can validly consent to a medical procedure, he or she must have been adequately informed of the risks and benefits of that risk. Now we shall discuss the exceptions to the defense of the maxim voluntary non fit injuria. There are certain exceptions or limitations to the application of this maxim. These are: number 1, illegal consent. No consent can legalize an unlawful act, for example, fighting with naked fists or duel with sharp swords. They are unlawful even if the parties may have consented. Number 2, breach of statutory duty. The maxim does not apply where the act of the plaintiff relied upon to establish the defense under the maxim is the very act which the defendant was under the duty to prevent. Thus, it is no answer to a claim made by a workman against his employer for injury caused through a breach by the employer of a duty imposed on him by statute. In Wheeler v. New Merton Boat Mills, the defendants installed a dangerous machine in their factory as a part of the plant with the intention that it should be used by their employees. The machine was not fenced or guarded as required by the Factories Act, and a workman in the employment of the defendant was injured by it in the course of his work. It was found that it was not by the negligence of the defendants but of their foreman that the machine had been allowed to be used in the condition in which it was used at the time of the accident. It was held by the Court of Appeal, dismissing the appeal that the defense of voluntary non-fit injuria was no answer to a claim made by a workman against his employer for injury caused through a breach by the employer of a duty imposed upon him by the statute. When a prisoner with known suicidal tendencies committed suicide while in the police custody, as the police failed to take reasonable precautions for preventing suicide, defense of the maxim could not be available to the police. For example, in Reeves versus Commissioner of Police of the Metropolis, the deceased was a prisoner known to be at the risk of committing suicide. While in police custody, he hanged himself in his prison cell. The commissioner accepted that he was in breach of his duty of care to the deceased, but not that the breach was causative of the death by suicide. The House of Lords held that the police and other officers of the state who take people into custody have a duty towards those so held of reasonable care. Where there was a known risk of self-harm or suicide, they had a duty to take reasonable steps to prevent such attacks. It was not open for them to plead voluntary non-fit injuria in defense of an action by the estate of the deceased. The third exception is negligence. This maxim has no application to cases of negligence. In Slater versus Clay Cross Company Limited, the plaintiff was struck and injured by a train driven by the defendant's servant while she was walking along a narrow tunnel on a railway track owned by the defendant. The defendants knew that the tunnel was used by the members of the public, and therefore they had instructed their servants to drive the vehicle slow while entering the tunnel. The accident took place because of the negligence of the servant, as he did not observe the instructions. It was held that the defendants were liable. Lord Denning said, I quote, "It seems that when this lady walked in the tunnel, although it may be said that she voluntarily took the risk of danger from the running of the railway in the ordinary and the accustomed way, nevertheless, she did not take the risk of negligence by the driver." Unquote. The fourth exception is rescue cases. The defense of voluntary non-fit injuria is not available in rescue cases. The rescuer is still expected to act reasonably, or he may be found guilty of contributory negligence. In Haynes versus Howard, the defendant's servant had left his van and horses unattended in a crowded street. The horses bolted when a boy threw a stone at them. The plaintiff was a policeman on duty inside a police station. He saw that if he did not act, a woman and a child would be in grave danger. He managed to stop both the horses, but in doing so, he suffered serious personal injuries. He was entitled to damages as a negligent act preceded the alleged consent. The Court of Appeal held that, I quote, "The doctrine of assumption of risk does not apply where the plaintiff has, under an exigency caused by the defendant's wrongful misconduct, consciously and deliberately faced a risk, even of death, to rescue another from imminent danger of personal injury or death, whether the person endangered is one to whom he owes a duty of protection as a member of his family, or is a mere stranger to whom he owes no such special duty." Unquote. Again, in Baker versus T.E. Hopkins and Son Limited, the defendant company was employed to clean out a contaminated well and decided to use a pump powered by a petrol engine inside the well. Having noticed that the pump produced noxious fumes, the director of the company instructed his workmen not to enter the well, but they did and were overcome by fumes. Baker, a doctor, went down in the well with a rope, but was also overcome by fumes and died in the well, as the two workmen did. The court of first instance allowed the actions brought by one of the workmen and Dr. Baker, although the workman was found to be contributory negligent at 10%. The appeals were dismissed. Lord Morris observed, I quote, "If A, by negligence, places B in peril in such circumstances that it is a foreseeable result that someone will try to rescue B and if C does so try, ought C in any appropriate sense to be described as a volunteer? In my judgment, the answer is no. I confess that it seems to me to be indeed ungracious of A even to suggest it. C would not have agreed to run the risk that A might be negligent, for C would only play his part after A had been negligent. C's intervention comes at the moment when there is some situation of peril and the cause of or the responsibility for the creation of the peril may be quite unknown to C. If C, actuated by an impulsive desire to save life, acts bravely and promptly and subjugates any timorous over-concern for his own well-being or comfort, I cannot think that it would be either rational or seemly to say that he freely and voluntarily agreed to incur the risks of the situation which had been created by A's negligence. When Dr. Baker arrived at the well, he proceeded to act as the promptings of humanity directed. He tried to save life. He tried to save the defendant company's servant. He was doubtless trying to do the very thing that the company hoped could be done. But in any event, what he did was brought about by and was caused by the negligence of the company. In these circumstances, the company cannot say that he was a volunteer." Unquote. Lord Morris's judgment indicates why voluntary non-fit injuria cannot be invoked against the rescuer. First of all, because his intervention occurred after a situation of peril had been created as a consequence of the defendant's negligence. He cannot be regarded as having assumed the risk of the defendant's negligence. Secondly, he proceeded to act as the promptings of humanity directed and not as a volunteer. Thus, for the maxim voluntary non-fit injuria to apply, knowing the risk of injury is not enough. Voluntary is not the equivalent of santai, but that it must be established that the plaintiff freely and voluntarily, with full knowledge of the nature and the extent of the risk he ran, implicitly agreed to incur it, and that the plaintiff elected to assume the risk. Now we come to the defense of voluntary non-fit injuria in sports cases. For liability to occur in competitive sports, it must be established either that the defendant failed to exercise a degree of care appropriate in all the circumstances, or that he acted in a way to which the plaintiff cannot be expected to consent. Justice Barwick of the High Court of Australia in Roots v. Shelton observed, I quote, "By engaging in a sport or a pastime, the participants may be held to have accepted risks which are inherent in that sport or pastime. The tribunal of fact can make its own assessment of what the accepted risks are, but this does not eliminate all duty of care of the one participant to the other, whether or not such a duty arises, and if it does, its extent must necessarily depend in each case upon its own circumstances. In this connection, the rules of the sport or the game may constitute one of those circumstances, but in my opinion, they are neither definitive of the existence nor of the extent of the duty, nor does their breach or non-observance necessarily constitute a breach of any duty found to exist." Unquote. Now we shall discuss voluntary non-fit injuria and contributory negligence. In case of voluntary non-fit injuria, the plaintiff is always aware of the nature and extent of the danger which he encounters, while it is not so in case of contributory negligence. Voluntary non-fit injuria is a complete defense, while in contributory negligence the claim of the plaintiff is reduced to the extent the claimant himself was to blame for the loss. Now we shall come to another defense under the law of torts, the defense of necessity. The law of torts, with a few exceptions, acknowledges necessity as a defense. It recognizes that there may be situations of such overwhelming urgency that a person must be allowed to respond by breaking the law. The defense of necessity arises when a person is forced to cause harm to prevent a greater harm from taking place. In this case, the defendant harms the plaintiff or the plaintiff's property in order to prevent a greater harm from taking place. An example of this defense being used is when a person enters another person's house in order to put out a fire so that it won't spread to the other houses. If the plaintiff or the owner of the house files against the defendant for trespass, the defendant can take the defense of necessity. Throwing goods overboard, a sinking ship to try and save it, pulling down a burning house to save the rest of the houses, pulling a drowning man out of the water, a surgeon operating upon an unconscious man to save his life, etc., are all examples of necessity. Now we shall discuss the elements of necessity. To gain the protection of the defense of necessity, it is not sufficient to have felt at that time that it was necessary to act. It can only be argued when, number one, where the action taken was necessary to prevent imminent harm to the person or property. Number two, where the defendant's trespassory act is considered as reasonable in the circumstances that existed and his or her actions were proportionate to the risk posed. In the case of protection of a person, it must also be established that, number one, there is a necessity to act where it is not practicable to communicate with the protected person. Number two, actions taken are what a reasonable person would take in the best interest of the protected person. Now, let us have a look at some of the cases on necessity. Lay versus Gladstone. In this case, the plaintiff was a prisoner who was undertaking a hunger strike. The defendant was the warden of the jail and he had to force feed her in order to save her life. The court held that the defendant was not guilty of the tort of battery. In Coop versus Sharp, the plaintiff's house caught fire and the defendant rushed inside and tried to put it out. The defendant was trying to put the fire out so that it could not spread to the nearby areas. The court ruled that the defendant was not liable for trespass as he had committed an act of necessity. Vincent versus Lake Erie Transportation Company is one of the most important and commonly cited American cases relating to private necessity. A steamship owned by Lake Erie Transportation Company was moored at Vincent's dock to unload cargo. A storm arose and the vessel was held secure to the dock, causing damages to the tune of $500 to the dock. Vincent sued to recover damage to the dock and the jury decided in favor of Vincent. The defendant appealed, alleging that it was not liable under the defense of private necessity. The court held that while the defendant cannot be held liable for trespass due to private necessity, he used the plaintiff's property to preserve his own and is therefore liable for resulting damages to the plaintiff. If the boat had remained secured to the dock without further action by the defendant, he would not have been liable. He was held liable because affirmative measures were taken to secure the boat. Necessity is different from private defense because in private defense, the plaintiff is harmed and the plaintiff is the person who is the wrongdoer. In the case of necessity, the person who is harmed is an innocent person. Necessity is also different from inevitable accident because in necessity the harm is intentional, whereas in an inevitable accident the harm is accidental. Now we come to another defense under the law of torts, the defense of the plaintiff as a wrongdoer. The law excuses the defendant when the act done by the plaintiff itself was illegal or wrong. This defense arises from the Latin maxim ex turbi causa non oritur actio, which means that no action arises from an immoral cause. So, an unlawful act of the plaintiff itself might lead to a valid defense under the law of torts. This maxim applies not only to tort law but also to contract, restitution, property and trusts. Where the maxim is successfully applied, it acts as a complete bar on recovery. According to Sir Frederick Pollock, when the plaintiff is a wrongdoer, he is not disabled from recovering damages unless the damage to his person occurred due to some wrongful act that he had committed. In a sense, if the plaintiff's actions are the determining cause of harm, the defendant can use the defense that the plaintiff is the wrongdoer. In Bird v. Holbrook, the plaintiff trespassed upon the land of the defendant. The defendant had set up spring guns in his property to defend it from trespassers. The plaintiff went into the defendant's land and was severely injured by the spring guns. The defendant had not put up a warning outside his garden saying that it was dangerous to trespass into the garden. The court found the defendant liable because he had used disproportionate force to react to the plaintiff's wrong, and also the defendant had forgotten about notifying people about the dangers of trespassing into the property. With this, we conclude today's lecture on certain defenses under the law of torts. Hope you have understood fully. Thank you and goodbye.